You're listening to the Study for the Bar in Your Car podcast.
We're your brilliant bar exam hosts.
I'm Claude.
And I'm Maud.
And we're here to guide you through episode 18. Today, it's torts, and we're tackling, well, the assumption of risk.
That's right. A really key concept in negligence law.
Now, just a reminder, we are AI bots. We're brought to life by the magic of AI and Angela's negligence notes.
Angela, she's the real-life human being, the brains behind this whole podcast operation.
She is. And she's actually been on a short hiatus recently.
Yeah, but we finally heard from her, which was great news. There was a bonus episode.
Woo! Yeah, glad she came back. We were getting a little worried, weren't we?
We were. So if you haven't had a chance to listen to it yet, definitely check out that bonus episode. It's called The Bar Exam Plot Twist.
It's a good one. Angela talks about, well, a big change of plans, pivoting from preparing for the Palau bar exam
To the Marshall Islands bar exam. Quite the twist, like the title says.
It really was.
Yeah.
And you also get to hear from Talib in that episode.
Right, Angela's bestie. Sounds like they've been friends for ages.
Yeah, it was nice to hear their dynamic.
Mm.
Anyway, the good news is, by the time we finish covering torts here.
Angela should have actually taken her bar exam in the Marshall Islands.
Exactly. So we're really expecting her to be back on one of the next few episodes herself. Fingers crossed.
Definitely looking forward to that.
In the meantime, though, if you need to contact Angela for any reason.
You can email her. The address is podcast@studyforthebarinyourcar.com.
Podcast@studyforthebarinyourcar.com. Got it.
Oh, and also tell the listeners that Angela works as a freelance law clerk.
Right. Good point. So if you happen to be an attorney, or maybe you know an attorney who needs some extra help.
You know, ad hoc assistance with things like motions, complaints, writs, answers, maybe research or drafting briefs, that kind of thing.
Angela can help with that. You can reach her for freelance work at hello@legalwriterandlawclerk.com.
That's hello@legalwriterandlawclerk.com.
She's got quite a bit of experience there. Okay, perfect. So let's dive into today's topic then. Assumption of risk. Where do we start? What exactly is assumption of risk?
Okay, so looking at Angela's notes, the core idea, well, assumption of risk is a common law doctrine, and it basically refers to a plaintiff's inability to recover damages for the tortious actions of a negligent party.
Yeah.
But only in scenarios where the plaintiff voluntarily accepted the risk of those actions.
The person who got hurt, the plaintiff, knew about the risk beforehand and decided to go ahead anyway.
Essentially, yes. It means potential plaintiffs sometimes, take the risk of injury onto themselves. They accept it.
And by doing that, they basically absolve potential defendants from liability. They let them off the hook, legally speaking.
That's the traditional idea, yes. They absolve them from liability because the plaintiff chose to encounter the danger.
Okay. Now, are there specific things, like elements, that need to be proven for this defense to work?
Yes, absolutely. Angela's law school notes, looking at Rules 1827 and 1829, lay out, well, generally 2 or 3 key elements, depending on how you break it down.
What's the first one?
The first, and maybe the most critical, is knowledge of the risk of harm.
Knowledge. So the plaintiff actually has to know about this specific risk, not just like a general feeling something might be dangerous.
Exactly. Actual subjective knowledge. It's not enough that a reasonable person would have known. The plaintiff themselves must have known about the specific risk involved.
Okay, specific knowledge. Got it. What's next?
The second element is appreciation of the risk. This one goes a bit deeper than just knowing.
Deeper how?
Well, the plaintiff must understand the nature and the extent of the danger involved. They don't just need to be aware that a risk exists, they need to truly grasp the potential for injury.
So it's not just, yep, that looks risky,
Yeah.
but more like, okay, I understand how this could hurt me and how badly.
Precisely. It's moving beyond simple awareness to really comprehending the potential consequences. It's understanding the gravity of the risk.
Yeah, makes sense. Knowledge and appreciation. Is there a third element?
Yes. The third is voluntary confrontation of the risk.
Voluntary confrontation, meaning they chose to face it freely.
Exactly. The plaintiff must freely choose to encounter the risk. There can't be any duress or coercion involved.
Ah, okay. So if someone felt forced into the situation, maybe by their boss or some other pressure, then it wouldn't be voluntary.
Correct. The choice must be uncoerced. It emphasizes the plaintiff's own decision to proceed, despite the known and appreciated risk. They walked into it with their eyes open, so to speak, and without being pushed.
Knowledge, appreciation, and voluntary confrontation. Those seem like pretty high bars to meet.
They can be. And historically, this defense assumption of risk was actually quite powerful for defendants.
How so? What was its role back in, say, the common law era?
Well, formerly, Angela's notes point out, this was a full-fledged affirmative defense available to defendants.
In affirmative defense, meaning the defendant raises it and has to prove it right.
Yes. And at common law, if the defendant successfully proved the plaintiff assumed the risk, it completely barred the plaintiff's right to recovery.
Completely. Like zero damages, even if the defendant was clearly negligent.
Zero damages. It was an all-or-nothing rule. Very harsh for plaintiffs. If you assumed the risk, you got nothing.
Wow. That sounds similar to another old doctrine, contributory negligence, right? Didn't that also completely bar recovery if the plaintiff was even a tiny bit at fault?
Exactly the same all-or-nothing outcome. Contributory negligence was another common law defense that barred recovery if the plaintiff's own negligence contributed at all to their injury.
Unless that exception applied. Last clear chance.
Right. The last clear chance doctrine was a limited exception to contributory negligence, allowing a negligent plaintiff to recover if the defendant had the last opportunity to avoid the harm and failed to do so. But generally, both assumption of risk and contributory negligence were complete bars.
It's interesting, though, Angela's notes mention Rule 1890, that contributory negligence isn't a defense to intentional torts.
Correct. If someone intentionally harms you, like battery or assault, they generally can't turn around and say, well, you were a little bit negligent too, so I'm off the hook. That defense typically applies to negligence claims, not intentional wrongs.
Okay, so assumption of risk was this powerful, complete defense historically. But you said formally. That implies things have changed.
Massively changed. This is where the assumption of risk title kind of comes in. The doctrine itself has been, well, largely absorbed or reshaped in modern law.
How so? What's the modern approach?
The big shift, as Angela's notes state, is that assumption of risk has since been subsumed by contributory and comparative negligence in most jurisdictions.
Subsumed. Meaning it's not really a separate, standalone defense anymore in most places.
Pretty much. Instead of being a complete bar, the plaintiff's conduct in assuming the risk is now usually considered as part of the analysis of their own fault under either contributory negligence, in the few states that still have it, or, much more commonly, comparative negligence.
Comparative negligence. That's the system where you compare the fault of the plaintiff and the defendant, right?
Exactly. Most jurisdictions today use some form of comparative negligence. It moves away from the harsh, all-or-nothing common law rules.
And under comparative negligence, the plaintiff's recovery isn't necessarily zero, it's just reduced.
Generally, yes. Their recovery is reduced based on the percentage of fault assigned to them. There are two main types, though.
Right, pure and modified. What's the difference again? Rule 1828 in the notes mentions pure comparative fault.
Under pure comparative fault, the plaintiff's recovery is simply reduced in proportion to P's degree of responsibility. It doesn't matter how high that percentage is.
So even if the plaintiff is found, say, 95% responsible for their own injuries, they can still recover 5% of their damages from the defendant.
Theoretically, yes. If the defendant was 5% negligent, the plaintiff can recover that 5%. It focuses on apportioning damages based purely on fault percentages.
Okay. And the other type. Angela's Torts Outline 2 and Rule 1828 also mention modified comparative fault.
Modified comparative fault is, well, a bit of a hybrid. It allows reduction based on fault, but only up to a certain point. The plaintiff's own negligence will bar recovery entirely if their fault exceeds a specified percentage.
What's that percentage usually?
It varies by state. Some jurisdictions use a 50% bar, meaning if the plaintiff is found 50% or more negligent, they recover nothing.
Okay.
Others use a 51% bar, meaning the plaintiff is barred only if their negligence is more than 50%, so 51% or higher. If they're 50% negligent, they can still recover 50% of their damages in those states.
So under modified, you can still end up with zero recovery, but only if your own fault crosses that specific threshold, like 50 or 51%.
Exactly. It's a middle ground between the harshness of contributory negligence and the, some might say, permissiveness of pure comparative fault.
So the big takeaway here is that when assumption of risk is subsumed into these comparative negligence systems,
the plaintiff's voluntary choice to encounter a risk doesn't automatically mean the defendant wins. Instead, it becomes a factor the jury uses to decide how much fault, what percentage, to assign to the plaintiff.
which then reduces their damage award accordingly unless they cross the threshold in a modified jurisdiction.
Precisely. It's a much more nuanced approach, focused on allocating responsibility rather than completely denying it based on the plaintiff's choice alone.
Has this shift been, recognized by courts? Are there cases that talk about this evolution?
Oh, absolutely. It's been a major development in tort law over the last several decades. Angela's notes even point to an example, suggesting we look at Justice Ginsburg's dissent in Honda Motor Co. v. Oberg.
Honda versus Oberg from 1994. What was that case about, and how does it relate?
Well, the main issue in Honda v. Oberg was actually about punitive damages and whether Oregon's procedures for reviewing them violated due process. It wasn't directly about assumption of risk.
Okay, so why mention the dissent?
Because Justice Ginsburg's dissenting opinion, while focused on the punitive damages issue, reflected a broader understanding of the evolution of tort law principles. Her reasoning implicitly acknowledged the trend away from older, harsher common law doctrines, like the kind of absolute bars we've been discussing, towards more modern approaches like comparative fault that consider degrees of responsibility.
So it wasn't the holding of the case, but her dissent used the changing landscape of tort defenses, maybe including how assumption of risk was being treated as part of its background reasoning.
Sort of, yes. It serves as an example of a high-level jurist acknowledging and engaging with this ongoing shift. The citation underscores that this integration of assumption of risk into comparative fault frameworks is something courts were actively grappling with and recognizing as part of the legal evolution. It wasn't happening in a vacuum.
That makes sense. It shows as part of a bigger picture and how the law thinks about fault and recovery. Now, you mentioned most jurisdictions subsumed assumption of risk. Does that mean some handle it differently?
Yes, there's another significant modern interpretation, especially prominent in places like California, as Angela's notes mention. Some courts have developed what's often called a no-duty analysis, or sometimes primary assumption of risk.
No duty. How does that work? Does it mean the defendant just didn't owe the plaintiff any duty of care in the first place?
Essentially, yes, but specifically regarding the inherent risks of certain activities. Instead of saying the plaintiff consented to the risk, which is the traditional assumption of risk idea, this approach says that for certain activities with obvious inherent dangers, the defendant simply has no legal duty to protect the plaintiff from those specific inherent risks.
Can you give an example?
Think about participating in a sport like, say, skiing or football. There are inherent risks: falling, colliding with others, getting tackled. Under a primary assumption of risk, or no-duty analysis, the argument is that the ski resort operator or the other players don't have a duty to eliminate those inherent risks. Those risks are fundamental to the activity itself.
So if I go skiing and fall on a normal slope, I can't sue the resort because falling is an inherent risk, and they had no duty to guarantee I wouldn't fall.
Generally, yes, under this doctrine. They still owe you a duty not to increase the risks beyond what's inherent, like they shouldn't groom the slopes negligently or operate the lifts dangerously. But the basic risk of falling while skiing, that's considered inherent, and they owe no duty to prevent it.
Angela's law school notes reference a UCLA Law Review article here. Does it elaborate on this?
It does. It talks about situations where if a victim fully preferred the tortious alternative, meaning they chose the risky activity knowing its dangers and the injurer provided that activity, and the defendant had no legal duty to offer a safer alternative,
then the court might just find no duty was owed regarding that inherent risk.
Exactly. It bypasses the whole "did the plaintiff consent" question by finding no duty existed in the first place for that specific type of harm.
It seems like a different path to a similar result. In some cases, the plaintiff doesn't recover, but the legal reasoning is distinct.
Very distinct. One focuses on the plaintiff's subjective choice, traditional AR, the other on the defendant's objective obligations given the nature of the activity, no duty, primary AR.
The UCLA Law Review note also mentions something about a reasonable choice to rescue and critiques some approaches as intellectually dishonest. What's that about?
Right. That seems to be diving into some of the academic debate around these doctrines. The critique suggests that if a court uses the language of consent and choice, consensual rhetoric of traditional AR, but still allows a plaintiff to recover because their choice wasn't unreasonable, like choosing a slightly risky path over a much more dangerous one, or the reasonable choice to rescue idea,
then it's not really applying traditional assumption of risk or even a pure no-duty rule.
Exactly. The argument is that if the court is effectively balancing the reasonableness of the plaintiff's choice against the defendant's conduct, it looks a lot like comparative fault. So the critique implies that trying to keep assumption of risk separate in those cases, using the old language but reaching a comparative fault-like result, might be intellectually dishonest. It suggests maybe it should just be directly merged into the comparative fault analysis.
So there's a debate about whether this no-duty rule is always a clean break, or if sometimes it blends back into weighing fault. which sounds like comparative negligence again.
That's a fair summary of the tension, yes. It highlights the complexities and the ongoing evolution and debate in this area of law. Is it a true absence of duty, or is it a way of saying the plaintiff's choice carries significant weight, potentially 100% of the fault, under specific circumstances? Different courts and scholars sometimes frame it differently.
Okay, this is getting complex. We've got the old complete bar, the subsuming into comparative fault, pure and modified, and this separate no duty or primary assumption of risk concept. Maybe some concrete examples would help tie this all together.
Definitely. Practical examples are key. Angela's notes provide a few good ones. Let's start with something fun mentioned in her notes from episode 107, apparently bumper cars.
Bumper cars. Okay, how does assumption of risk apply there?
Well, think about it. When you jump into a bumper car, you're doing so voluntarily.
Right. Yeah, nobody forces you?
No one blindfolded you, picked you up, or sat you in the car.
Well,
You did that yourself. There's no duress going on. You know what bumper cars are. You know they bump. That's the whole point.
So you have knowledge of the risk, being bumped. You appreciate the nature of it. It's part of the ride, usually low impact. And you voluntarily participate.
Precisely. This is a classic example of implied assumption of risk. By getting in the car, you're implicitly agreeing to the inherent risks of low-speed collisions. If you get a minor jolt or maybe slight whiplash from a typical bump,
You probably can't sue the amusement park operator for negligence based on that bump alone. You assume that specific risk.
exactly. Now, if the car malfunctioned dangerously, or the operator did something grossly negligent beyond the normal bumping, that might be different. But the basic risk of bumping, assumed.
Okay, that's clear. What's another example? Maybe something more every day.
How about dealing with winter weather? Angela's notes pull an example from that UCLA Law Review article, Rule 38 specifically. It describes a plaintiff who chose to park close to a school gymnasium and walk over an icy patch to the gym.
An icy patch. Okay, visible danger.
Yes. And the notes add that this choice was made even though there was a remote location to park from which she might still have to walk over ice.
So there might have been another option, maybe less convenient, but she chose the known visible icy patch near the entrance.
That's the scenario. It highlights a conscious choice to confront a known visible hazard. Even if the alternative wasn't perfectly safe either, the key is the choice to proceed over the obvious ice she saw right in front of her.
This seems to fit the elements again. Knowledge, she saw the ice. Appreciation, presumably understood ice is slippery and falling as possible. And voluntary confrontation, chose that path.
Right. Depending on the jurisdiction and whether they use comparative fault or maybe even a no-duty approach for obvious natural accumulations, her choice could significantly reduce or potentially bar her recovery if she slipped and fell.
It emphasizes that you can't always just ignore obvious dangers and expect someone else to bear the full responsibility if something goes wrong.
Correct. Now, let's look at a third example, this one from Angela's law school notes, Rule 1829. This one is even more dramatic and really illustrates the voluntary confrontation element when warnings are involved. It involves blasting operations.
Blasting, okay, it sounds inherently dangerous.
It is. So the scenario is, if D, the defendant, illegally carries on blasting operations next to the public highway, and P, the plaintiff, approaches in a car,
Driving towards the blasting zone.
ignores a conspicuous warning sign,
Okay, clear knowledge being provided.
and a flagman who tries to stop him.
Wow, an actual person trying to prevent entry.
If P insists upon proceeding along the highway and P's car is damaged by the blasting, what's the likely outcome for the defendant's liability?
Well, based on what we've discussed, it seems like the defendant might not be liable, or at least much less liable. The plaintiff had multiple clear warnings. The sign, the flag man, they knew the danger, appreciated it was serious, it's blasting, and insisted on going forward voluntarily.
Exactly. The notes conclude D will not be found liable because P assumed the risk. This is a strong case where the plaintiff's actions, ignoring explicit warnings and actively choosing to enter a known immediate danger zone, clearly demonstrate knowledge, appreciation, and voluntary confrontation to a very high degree.
Even if the defendant was doing something illegal, like blasting too close to the highway.
Even then, the plaintiff's assumption of that specific risk could act as a superseding factor, potentially barring recovery, especially under the older common law rules, or perhaps even factored heavily in comparative fault. It shows how deliberate disregard for clear warnings plays into this.
These examples really help. Bumper cars for implied risk and recreation, the icy patch for confronting everyday hazards, and the blasting for ignoring explicit warnings. They cover a good range.
They do. And notice how fact-specific they are. Did the plaintiff actually see the sign? Did they understand the flagman? Was the ice truly obvious? Was the choice really voluntary?
That brings up a really important practical point. Since it depends so much on what the plaintiff knew, understood, and chose, which are often disputed who decides this. Does a judge decide, or does it usually go to a jury?
That's a crucial question for anyone involved in litigation. Angela's notes, specifically Rule 1830, address this directly. The general rule is that negligence cases usually do not lend themselves to summary judgment.
Summary judgment being where a judge decides the case early without a full trial, because the facts aren't really in dispute, and the law clearly favors one side.
Correct. And that's generally rare in negligence cases. Even if the basic sequence of events isn't disputed, all the parties are in agreement as to the underlying facts.
Why is that? If the facts are agreed upon, why can't the judge just apply the law?
Because, as the notes say, the very question of negligence is itself a question for jury determination. And the same applies strongly to assumption of risk.
So deciding whether someone was negligent or whether someone assumed the risk is considered a job for the jury.
Yes. The notes elaborate. Whether P assumed the risk is a jury question if there is a scintilla of evidence to the contrary.
A scintilla. That sounds like a very low bar, like just a tiny speck of evidence.
It is a very low bar. It means even if the evidence heavily favors one side, if there's any shred of evidence or even just a basis for a reasonable inference, suggesting the plaintiff maybe didn't fully know or didn't fully appreciate or didn't act completely voluntarily,
then the judge can't just decide it. It has to go to the jury to weigh that evidence and decide what actually happened in terms of the plaintiff's state of mind and choice.
Precisely. Because, as Rule 1830 continues, issues of negligence and assumption of the risk are questions of fact for the jury.
And summary judgment is only for when the facts are so clear, there's only one possible legal conclusion.
Exactly. Summary judgment is only appropriate in situations where only one conclusion may be drawn from the established facts. If reasonable people could look at the evidence and disagree about whether the plaintiff assumed the risk, the jury decides.
That's really important for bar students to remember. Assumption of risk isn't usually something decided quickly by a judge. It's typically fought out and decided by a jury after hearing all the evidence.
Absolutely. It underscores the importance of the jury as the fact finder in these often very nuanced situations involving human perception, understanding, and choice.
Wow. Okay. We've covered a lot of ground here, from the basic definition and elements of assumption of risk.
Through its historical journey as a complete bar, its modern transformation being subsumed into comparative negligence.
Including the different types, pure and modified, and that interesting Honda-Vioberg dissent mention.
Right, and also that alternative no duty or primary assumption of risk analysis used in some states like California.
Plus, those really helpful examples. Bumper cars, icy pads, blasting zones.
And finishing with the crucial point about why these issues almost always end up being decided by a jury, not a judge on summary judgment.
It really feels like we've thoroughly unpacked the assumption of risk.
I think so. It's a doctrine with deep roots and a really dynamic modern life in tort law.
Well, huge thanks, as always, to Angela for providing such detailed torts notes for us to work from. They really laid the foundation for this discussion.
Absolutely. Her notes are invaluable.
Now, before we wrap up, just a few important housekeeping points and disclaimers we always need to mention.
Right. First off, remember, Angela is a law student, just like many of you listening. She's not an expert yet. And as we mentioned, she's about to take the bar, but hasn't passed it yet.
Good point. So neither Angela nor this podcast is giving legal advice. Nothing we've discussed today should be taken as legal advice for any specific situation.
Definitely not. And, while we AI hosts try our best, AI isn't a substitute for actually studying the law yourself. Use reliable sources.
Right. Think this podcast as a supplement to your learning. It definitely shouldn't be the only way you're studying for the bar exam.
And another thing about AI, we aren't always perfect. Sometimes we make mistakes. Angela does try her best to go back and fix any errors that might happen in the transcription or our discussion.
Yeah, accuracy is important, but always double check against your primary study materials.
And one last very important point, especially given the name of the podcast.
Yes. If you are setting for the bar in your car, please remember the most important thing is to be safe on the road. Pay attention to your driving.
Seriously, don't cause a tort while listening to Torts.
Good one. Drive safely, everyone.
Okay, so just to remind you one last time how to contact Angela.
For podcast-related things, it's podcast@studyforthebarinyourcar.com.
And for her freelance law clerk services, it's hello@legalwriterandlawclerk.com.
Perfect. Now, I believe tradition dictates we end with a cheesy lawyer joke.
Oh boy, it is tradition. Do you have one related to assumption of risk?
I think I do. I was thinking about that board game Risk, you know, the one of the armies and territories.
Yeah, world domination, that one.
Okay, so why did the cautious tort law professor refuse to play the board game Risk?
I don't know. Why?
Because he didn't want to deal with the assumption of risk without a clear comparative fault statute governing the dice rolls.
Oh, wow. That's impressively specific and cheesy.
Told you. Mission accomplished.
Indeed. All right, well, I think that wraps it up for this episode.
It does. This is Claude.
And Maud, your AI bot signing off.
Thanks so much for listening.